Video is part 3 of outstanding features of our constitution. Compromise between judicial review and parliamentary supremacy. Indeed, the harmonization which our constitution has effected between parliamentary sovereignty and a written constitution with a provision of judicial review is a unique achievement in the frame of the framers of our constitution. An absolute balance of powers between the different organs of government is an impracticable thing, and in practice the final say must belong to someone of them. This is why the rigid scheme of separation of powers and checks and balances between the organs in the Constitution of the United States has failed in its actual working. And the judiciary has assumed supremacy under its powers of interpretation and of the Constitution to such an extent as to deserve the epithet of the safety valve or the balance wheel of the Constitution. As one of her own judges has said, Chief Justice Hughes, the Constitution of the USA is what the Supreme Court says it is. It has the power to invalidate a law duly passed by the legislature, not only on the ground that it transgresses the legislative powers vested in it by the Constitution or by the prohibitions contained in the Bill of Rights, but also on the ground that it is opposed to some general principles set to underline vague expression, such as due process, the contents of which not being explicitly laid down in the Constitution, are definable only by the Supreme Court. The American judiciary thus sits over the wisdom of any legislative policy as if it were a third chamber or super chamber of the legislature. Under the English Constitution, on the other hand, Parliament is supreme and can do everything that it is not naturally impossible. Blackstone and the courts cannot nullify any act of Parliament on any ground whatsoever, as May puts it. The Constitution has assigned no limits to the authority of Parliament over all matters and persons within its jurisdiction. A law may be unjust and contrary to the principles of sound government, but Parliament is not controlled in its discretion, and when it errs, its errors can be corrected only by itself. So English judges have denied themselves any power to sit as a court of appeal against Parliament. The Indian Constitution wonderfully adopts the via media between the American system of judicial supremacy and the English principle of parliamentary supremacy by endowing the judiciary with the powers of declaring a law as unconstitutional if it is beyond the competence of the legislature according to the distribution of powers provided by the Constitution, or if it is in contravention of the fundamental rights guaranteed by the Constitution or of any other mandatory provisions of the Constitution, Articles 286, 299, 301, 304, but at the same time depriving the judiciary of any power of judicial review of the wisdom of legislative policy. Thus, it avoided expressions like due process and made fundamental rights such as that of liberty and property subject to regulation by the legislature. But the Supreme Court has discovered due process in Article 21 in Maneka Gandhi. Further, the major portion of the Constitution is liable to be amended by the Union Parliament by a special majority. If in any case the judiciary proves Further, the major portion of the Constitution is liable to be amended by the Union Parliament by a special majority if in any case the judiciary proves two obtrusive, the theory underlying the Indian Constitution in this respect can hardly be better expressed than in the words of Pandit Nehru. No Supreme Court, no judiciary can stand in judgment over the sovereign will of the Parliament, representing the will of the entire community. It can pull up that the sovereign will if it goes wrong, but in the ultimate analysis, where the future of the community is concerned, no judiciary can come in the way. Ultimately, the fact remains that the legislature must be supreme and must not be interfered with the courts of law in such measures as social reform. Our Constitution thus places the supremacy at the hands of the legislature as such as that is possible within the bounds of a written constitution. But as has been mentioned earlier, the balance between parliamentary sovereignty and judicial review was seriously disturbed, and a drift towards the former was made by the Constitution 42nd Amendment Act 1976 by inserting some new provisions, as for example Article 31D, 32A, 131A, 144A, 226A, 228A, 323AB, 329A. The Janata government coming in power in 1977 restored the pre-1976 position to a substantial extent through the 43rd and 45th Amendments 1977-78 by repealing the following articles, which has been inserted by the 42nd Amendment: 31D, 32A, 131A, 144A, 226A, 228A, 329A, and by restoring Act 226 to its original form substantially. On the other hand, the judiciary has gained ground by itself, declaring that judicial review is a basic feature of our Constitution, so that so long as the Supreme Court itself does not revise its opinion in this behalf, any amendment of the Constitution to take away judicial review of legislation on the ground of contravention of any provision of the Constitution shall itself to be liable to be invalidated by the court. See at the end of this chapter. Fundamental rights subject to reasonable regulation by legislature. The balancing between supremacy of the Constitution and the sovereignty of the legislature is illustrated by the novel Declaration of Fundamental Rights, which our Constitution embodies. The idea of incorporating in the Constitution a Bill of Rights has been taken from the Constitution of the United States, but the guarantee of individual rights of our Constitution has been very carefully balanced with the need for the security of the state itself. American experience demonstrates that the written guarantee of fundamental rights has a tendency to engender an atomistic view towards society and state, which may at times prove to be dangerous to the common welfare. Of course, America has been saved from the dangers of such a situation by reason of her judiciary propounding the doctrine of police powers, under which the legislature is supposed to be competent to interfere with the individual rights wherever they constitute a clear danger to the safety of the state and other collective interests. Instead of leaving the matter to the off chance of judicial protection in particular cases, the Indian Constitution makes each of the fundamental rights subject to legislative control under the terms of the Constitution itself. Apart from those exceptional cases where the interests of national security, integrity, or welfare should exclude the application of fundamental rights altogether. Article 31A to 31C. Another peculiarity of the chapter on fundamental rights in the Indian Constitution is that it aims at securing not merely political or legal equality but social equality as well. Thus, apart from the usual guarantees that the state will not discriminate between one citizen and another merely on the ground of religion, race, caste, sex, or place of birth in the matter of appointment or other employment offered by the state, the Constitution includes a prohibition of untouchability in any form and lays down that no citizen may be deprived of access to any public place of the enjoyment of any public amenity or privilege. only on the ground of religion, race, caste, sex, or place of birth. We can hardly overlook in this context that under the Constitution of USA, racial discrimination persists even today, notwithstanding recent judicial pronouncement to the contrary. The position in the United Kingdom is no better, as demonstrated by current events. Another feature which was not in the original Constitution has been introduced by the 42nd Amendment 1976 by introducing Article 51A as Part 4 of the Constitution. Though the directive in Part 4 of the Constitution were not enforceable in any manner and had to give way before the fundamental rights, under the original Constitution, the situation was reversed through the back door by the 42nd Amendment 1976 by amending Article 31C, shielding all the directives in Part 4 of the Constitution from the fundamental rights in Part 3, but this object has been frustrated by the majority decision in the case of Minerva Bills versus Union of India, as a result of which Article 31C will shield from unconstitutionality on ground of violation of Article 13 those laws which implement only the directive specified in Article 39 BC and not any other directive included in Part 4 of the Constitution. In the same direction, the 42nd Amendment introduced fundamental duties to circumscribe the fundamental rights, even though the duties as such cannot be judicially enforced. See further under Chapter 8 Post. The adoption of the universal adult suffrage with any qualification either of sex, property, taxation, or the like is a bold experiment in India, having regard to the vast extent of country and its population with an overwhelming illiteracy. The suffrage in India, it should be noted, is wider than that in England or the United States. The concept of popular sovereignty, which underlies the declaration of the preamble that the Constitution is adopted and given by the people of India unto themselves, would indeed have been hollow unless the franchise, the only effective medium of popular sovereignty in the modern democracy, were extended to the entire adult population, which was capable of exercising the right, and an independent electoral machinery under the control of election commission was set up to ensure the free exercise of its. The electorate has further been widened by lowering the voting age from 21 to 18 by the 61st Constitution Amendment Act 1988. That notwithstanding the outstanding difficulties this bold experiment has been crowned with success will be evident from some of the figures relating to the first general election held under the Constitution in 1952. Out of a total population of 356 million and an adult population of 180 million, the number of voters enrolled was 173 million, and of these no less than 88 million, that is over 50% of the enrolled voters, actually exercised their franchise. The orderliness with which 11 general elections have been conducted speaks eloquently of the political attainment of the masses, though illiterate, of this vast subcontinent. In the 11th general election held in 1996, the number of persons on the electoral roll had come up to 550 million. No less creditable for the framers of the Constitution is the abolition of communal representation, which is in its trail had brought in the bloody and lamentable partition of India. In the new Constitution, there was no reservation of seats except for the scheduled caste and scheduled tribes and for the Anglo-Indians, and that only for the temporary period. This period was 10 years of the original Constitution, which has been extended to 60 years or till today, that is up to 2024 AD by subsequent amendments of Article 334. 13. It has been stated at the outset that the form of government introduced by our constitution, both the union and states in the parliamentary government of the British type, a primary reason for the choice of this system of government was that the people had a long experience of this system under the Government of India Acts. Though the British were very slow in importing its features to the fullest length, the makers of our constitution rejected the presidential system of government as it obtains in America on the ground that under the system the executive and the legislatures are separate from the independent of each other, which is likely to cause conflicts between them which our infant democracy could ill afford to risk. But though the British model of parliamentary or cabinet form of government was adopted, the hereditary monarch or ruler at the head could not be installed because India has declared herself a republic instead of a monarch. Therefore, an elected president was to be at the head of the parliamentary system. In introducing this amalgam, the makers of our constitution followed the Irish precedent. This is all about today's part of outstanding features of our constitution. Thanks, regards.